Court now in session. Honorable Roy J. Mink presiding.
You may be seated. In the case of People versus Tanya Marie Fent.
Good morning, Your Honor. May it please the court, Scott Moore, the defendant probation.
Good morning, Your Honor. Mark Bell on behalf of the people.
You are Tanya Marie Fent.
That is correct.
Set for probation. Raymond.
Yes, Your Honor. It's my understanding that the petition arises from one or more transactions or occurrences in two separate counties. Those matters are pending in those counties. For that reason, we would waive reading of the petition, stand guilty to the charge, and waive any requirement that the hearing be held in 14 days, as if this matter be set out approximately 30 to 45 days.
Not guilty pleas will be entered on behalf of the defendant. We'll set this for a status conference about 45 days out.
Thank you, Your Honor.
You're all set, Ms. Fent.
Thank you.
What do you wish to do next? More.
We have Mr. Manny from the Department of Corrections on Zoom, and we have Mr. Williams present in the courtroom.
Calling the cases of People versus Anthony James Many. Also identify for the record, please.
Judge Mark Webb on behalf of the people. But I apologize. This isn't my case. I haven't had a chance to look at the pre-sentence reports. This is a sentencing.
Sentencing. There was a sentencing for a BK at 12 months. Mr. Many's already in prison. He pled to operating while intoxicated or impaired or under controlled substance, third offense, plus a habitual third, makes that a felony with a maximum of 10 years in prison. Sentencing guidelines are 5 to 34 months. The court's not inclined to do a BK at 12 months in this matter. The court would do a sentence of 16 months to 10 years, and then time served on the probation violation. And I believe the court's right, that would not extend his earliest release date.
I believe Your Honor is correct. My client has indicated to me that his earliest release date is January 1st, 2023. So I believe that would be within that period. Mr. Many, when we spoke, we did discuss that the recommendation might be exceeded. What the judge has said, and he has not sentenced you yet, but he is saying he is inclined to essentially run the sentence concurrently with what you're serving now. 16 months dating back to the arrest date. You get credit for the time served. This should not interfere with your earliest release date on the Aranac County sentence. Do you understand that?
Yes, sir.
You have the right to withdraw your plea if it does not follow the Briggs-Killebrew agreement. I'm saying this on the record. All things being equal, I would suggest that you accept the sentence that's been at least implied or suggested by the judge at this point. Do you understand that?
Yes, sir.
And then you would plead or be sentenced on the probation violation to essentially the time served with the unsuccessful discharge. Do you understand that?
Yes, sir.
Thank you. We'll proceed without withdrawing.
All right. Okay. And or you have had an opportunity to review that pre-sentence investigation report and the updated case report with your client.
Yes, Your Honor.
Anything of a factual nature that you wish to add to explain or controvert in either report?
No, Your Honor.
Any challenges to the scoring of the guidelines?
No, Your Honor.
Mr. Webb, on behalf of the people, anything regarding the factual nature of the report or the scoring of the guidelines?
Judge, if I could just have a minute to just glance over those.
Okay.
Thank you.
For the record, guidelines were scored 0 to 17 on the probation violation charge, of which was an assault. police officer assaulting, resisting, or obstructing charge with a maximum penalty of 2 years in prison. 2 counts of that, and 1 count of a misdemeanor operating while under the influence. Mr. Manny is waiving the right to be present in the courtroom for sentencing. Is that correct, Mr. Moore?
Yes, Your Honor.
Thank you, Your Honor. I've had a chance to review the report. I have no additions or corrections to make to it. And I believe the guidelines are correct as well.
Mr. Manny, is there anything you wish to say to the court before the court passes sentence?
No, Your Honor, there's nothing I'd like to say.
Mr. Moore, on behalf of your client.
Thank you, Your Honor. I would ask the court to at least partially honor the Briggs-Killebrew agreement and allow the sentence to run currently with this other sentence in Aranac County as well as the probation violation. With that, I believe that I have properly advised my client of his rights under People versus Briggs-Killebrew. He is electing to go forward with sentencing on that basis. I ask the court to take that into account as well. Thank you.
Mr. Webb, on behalf of the people.
Judge, I guess, I understand you're gonna oppose the 16 months to 10 years, regardless of our recommendations. I ask you to do that.
Court has reviewed through the pre-sentence investigation report that provides the sentencing guidelines of 5 to 34 months. In order to punish you for what you have done, to attempts to rehabilitate you, deter others from committing similar acts, in protection of the community, be the sentence of this court that you be sentenced to the Michigan Department of Corrections for a period of 16 months to 10 years. The court will give credit for 180 days served. A restitution amount of $235, a $68 state cost, crime victims assessment of $130. How much are you charging for attorney fees?
In both files, it would be $300. Apply that to.
Court will assess $300 for the attorney fees in this file. There'll be no fines or costs in that file. As to the probation violation, the court will revoke probation. It's unsuccessful. Sentence him to time served on all 3 counts. No additional fines and costs in that file. You are entitled to appellate review of your convictions and sentences. If you're unable to hire your own attorney, the court will appoint an attorney for you and furnish the attorney with the necessary records and transcripts to perfect an appeal. The request for the appointment of appellate attorney must be made in writing within 42 days sent directly to the court. Please sign the notice of appellate's rights form. Bond is canceled. You're remanded to the custody of Michigan Department of Corrections for carrying out the sentence. Good luck to you, Mr. Manny. Get on top of those problems.
Mr. Hamilton, can you hear the court?
Yes, I can.
Thank you.
Calling the cases of the people versus Marcus Garvey Hamilton. Counsel identified for the record.
Morning, Your Honor. Mark Webb on behalf of the people.
Since the court's got more for the defense, Your Honor, I would ask this matter. I would like to speak to Mr. Hamilton before we proceed. As I indicated earlier, Mr. Williams is present here.
All right, we'll pass this matter aside. We'll call the case of the people versus Joshua Christopher Williams.
Mr. Hamilton, I'm gonna move you to a breakout room. Just say join when I put you there, okay?
Okay.
Show resides for your people.
This court's got more for the defense.
You are Joshua Christopher Williams.
Yes.
This is set as a pretrial. The pretrial summary has been presented to the court. Did you receive that, Mr. Moore?
I did, Your Honor. I would ask the court's indulgence to allow me to discuss this with my client. Set this matter for a status conference. We're neither rejecting nor accepting the plea at this time, but I believe that we're very close to a resolution.
Okay. Do you want this set for a status conference in 2 weeks?
I think 2 weeks would be sufficient, Your Honor.
All right. Set this for a status conference in 2 weeks. The court has signed the pretrial summary.
Judge, do you have the date of that next hearing by chance?
Okay, let's see. Should be the 23rd at 8:45 a.m.
Thank you.
Anything else you want to take up before we go into the breakout room with Mr. Hamilton?
Okay, thank you.
All right, we're in recess.
All rise. All rise. Court's back in session. Honorable Roy J. Mink presiding.
You may be seated. Calling the cases of People versus Marcus Garvey Hamilton. Counsel identify for the record, please.
Morning, Your Honor, Mark Webb on behalf of the people.
And please support Scott Moore for the defense.
You are Marcus Garvey Hamilton.
Yes, Your Honor.
Previously, you appeared in court and pled to the charge of controlled substance possession of methamphetamine in file 21-6657-FH, a felony that carries the maximum penalty of 10 years in prison. Minimum is discretionary for court. Sentencing guidelines were determined to be 0 to 17 months, and in file number 21-6659-FH, you pled to the charge of controlled substance use of methamphetamine. A misdemeanor carries a maximum penalty of 1 year in the county jail. Mr. Moore, have you had an opportunity to review that pre-sentence investigation report with your client?
Yes, Your Honor.
Anything of a factual nature that you wish to add to, explain, or controvert in that report?
No, Your Honor.
Mr. Webb, on behalf of the people.
Thank you, Your Honor. I reviewed the report. I have no additions or corrections to make to it. The guidelines are correctly scored.
Mr. Hamilton, is there anything you wish to say to the court before the court passes sentence?
I wish to say that my drug use I chose is not right. I cannot blame anything on anybody but myself for the choices I have made. I just wish to, in this time of incarceration, to make myself better and get into rehab and live a drug-free life from now on.
More on behalf of the client?
Thank you, Your Honor. We are going to ask the court to deliberate agreement in both files and that any sentence imposed will run concurrently. Mr. Garvey is pending sentencing probation violation and one other charge in Gladwin County that's scheduled for about 2 weeks from now. Methamphetamine use has a role to play in all of these offenses. Intermediate sanction is suggested by the guidelines. Gillibrew Camp is just that. But there's also a misdemeanor for which there are no sentencing guidelines. We would ask the court to fashion a sentence that would stay within the cap and allow my client an opportunity for inpatient rehabilitation. After having discussions with both Agent Brubaker and Agent Brady in Gladwin County, it sounds likely that Mr. Hamilton now has increased insight into his substance use disorder. Thank you.
Mr. Webb, on behalf of the people.
Your Honor, I just asked the court to follow the plea agreement and the recommendations from the probation department.
The court has reviewed through the pre-sentence investigation report. Does provide for sentencing guidelines on the felony file of 0 to 17 months. In order to punish you for what you have done, to attempts to rehabilitate you, deter others from committing similar acts, protection of the community. And file 21-6659-FH will be the sentence of this court that you be sentenced to 1 year in the county jail with credit for 98 days served. You must be assessed state costs. I'm not sure, is that still $50 in state costs or
I
for a
believe so.
misdemeanor?
I believe so, Your Honor.
And $130 for crime victims of the lesser cost for misdemeanors too.
I think that's 130.
$130 crime victims assessment. Are you charging separately for the attorney fees, or are you putting them all in one file?
Yeah, we can put them on the felony file.
The court has no objection to going into a rehab at the end of the sentence. As far as file 21-6657-FH, the sentence of this court that you be placed on probation for a period of 2 years. Along with the statutory terms of probation are the following special conditions. You must not use or possess alcoholic beverages or other intoxicants or enter any places that serve alcohol. You must comply with the requirements of alcohol testing as directed by the field agent. You must comply with the requirements of drug testing as directed by the field agent. Must not use or possess any controlled substances or drug paraphernalia unless prescribed for you by a licensed physician or be with anyone you know to possess these items. You must use prescription drugs only as prescribed for you by your licensed physician. You must complete outpatient or residential substance abuse treatment when referred by the field agent. You must complete a substance abuse assessment when referred by the field agent. You must waive confidentiality and allow any treatment program that you are required to attend to disclose information to your field agent. You must not engage in any assaultive, abusive, threatening, or intimidating behavior. You must not have any verbal, written, electronic, or physical contact without permission of the field agent with anyone you know to have a felony record. You must not change your residence unless you first obtain written permission from the field agent. You must not use any object as a weapon. You must contact the supervising field agent no later than the first business day following your placement on probation or release from jail. You must comply with all written and verbal orders made by the field agent. You must allow the field agent into your residence at any time for probation supervision. You must submit to a search of your person or property without the need of a warrant if the field agent has reasonable cause to believe you have items which violate your conditions of probation. You must report any arrest or police contact, loss of employment, or change of residence to the field agent within 24 hours, weekends and holidays accepted. You must notify the field agent of service of any personal protection order upon you in 24 hours of that service, weekends and holidays accepted. You must make genuine efforts to find and maintain legitimate employment. You will serve 12 months in the county jail with credit for 98 days served. That'll run concurrent with the other case. Must comply with DNA testing, pay a $60 fee. If one hasn't been paid already, you must pay $68 state costs in this file. Crime victims assessment of $130 in this file. Court cost of $500, a fine of $500, and how much are for the attorney fees?
$620.
$620 in a court-appointed attorney fees. Let's pay a supervision fee of $30 a month. That can go to $60 a month if the Department of Corrections decides to put you on electronic monitoring. Probation officer of this court or any other supervising agent may, pursuant to MCL 771.4, apprehend, detain, and confine a probationer who is in violation of probation condition or who is conducting himself inconsistent with the public good. You're not allowed to use or otherwise possess recreational marijuana or be in the home of anyone who uses recreational marijuana. You must not possess, purchase, or attempt to purchase anything that contains ephedrine or pseudoephedrine without first obtaining permission from your field agent. Court has to,
It's a 1-year sentence, Your Honor.
I know, but it's not over 1 year. Unless it's the prison,
Very
the
good.
court has to oppose the license.
Certainly, Your Honor.
So the license is suspended for at least 1 year, restrictively allowed after 60 days. Must set up an installment payment agreement with the Clark County Clerk's Office within 30 days of your release from jail. The court has no objection to you going into an inpatient program at the end of the sentence. The court would suspend any time if you successfully complete that inpatient program. You are entitled to appellate review of your convictions and sentences. If you're unable to hire your own attorney, the court will appoint an attorney for you and furnish the attorney with the necessary records and transcripts to perfect an appeal. The request for the appointment of appellate attorney must be made in writing within 42 days, sent directly to the court. Please sign the notice of appellate's rights form when it's presented to you. Bond is canceled. You're remanded to the custody of the Sheriff's Department for carrying out the sentence.
Thank you.
Good luck to you, Mr. Garvey.
Thank you.
Or Mr. Hamilton.
Garvey, Hamilton, it's all the same.
Yeah, okay. Who do you want to call next?
If Mr. Meister is available, we can
Next
go to
is
him.
next.
Just wait. Your Honor, may we approach?
You may. Going the case of the people versus Stephen Anthony Mexner. Some close up.
Sure, besides currently have people.
Is the court Scott Moore for the defense?
You are Stephen Anthony Mexner.
I am, Your Honor.
This was set as an arraignment. How do you wish to proceed, Mr. Moore?
Thank you, Your Honor. Waive reading of the information, waive preliminary examination, stand into the charge and ask for this matter to be set for a pretrial conference. It's my understanding that Mr. Meister has 2 other matters scheduled for final pretrial conference on August 24th. Mr. Meister has expressed concerns about his bond situation. I did receive an email from the prosecutor weekend indicating that Global Resolution may be in the offing and might be able to address bond. So for those reasons, I would ask for this matter to be set for a pretrial conference on August 24th.
All right. Not guilty pleas will be entered on behalf of Mr. Mexner. This will be set for a pretrial on August 24th with the other cases. And feel free to do a written motion for bond or that's
Yes.
part of your discussion with the prosecutor.
Yes, sir. Thank you very much.
All right. You're all set, Mr. Mexner.
Thank you very much. Have a great day.
Yes.
We're gonna adjourn Mr. Yass so they can leave him.
Would you like
Adjourn it for 2 weeks?
Mr. Wiki then next?
Yes.
I would, if I could speak to you.
Mr. Wiki. All right, court will take a short recess.
All rise. All rise, court's back in session. Honorable Roy G. Mink presiding.
You may be seated. In the case versus Richard Lee Wiki.
You show me size screen on next people.
And please, the court, Scott Moore from defense.
You are Richard Lee Wiki.
Yes, sir.
Previously, you appeared in court and pled to the charge of peace officer lying to a 4 year or more crime investigation. That is a high court misdemeanor, carries a maximum penalty of 2 years in prison. Minimum is discretionary of the court. Pre-sentence investigation report has been prepared. Sentencing guidelines have been determined to be 0 to 11 months. Mr. Moore, have you had an opportunity to review that police pre-sentence investigation report?
Yes, Your Honor.
Anything of factual nature you wish to add to explain or controversy?
No, Your Honor.
Any objection to the scoring of the guidelines?
Thank you.
Ms. Ambrositis, on behalf of the people?
Your Honor, we've had the opportunity to review the pre-sentence investigation report. We do find it to be factually accurate. We've also reviewed the prior record variable scoring and the defense variable scoring and find it to be accurate as well.
Mr. Wiki, is there anything you wish to say to the court before the court passes sentence?
No, sir.
Mr. Moore, on behalf of your client?
Your Honor, we asked the court to follow the Briggs-Killer agreement in this case. And I should point out that my client is desirous of a mental health assessment and treatment. I recognize that that is a condition of the proposed probation order, but he supports that vote. Thank you, Your Honor.
Ms. Ambrositis, on behalf of the people?
We asked to follow the recommendations and the plea agreement.
Are there any victims present that wish to speak to the issue of sentencing? Let the record reflect there are no victims present either in the courtroom who wish to speak or via Zoom. Court has reviewed through the pre-sentence investigation report, does provide for sentencing guidelines of 0 to 11 months. In order to punish you for what you have done, to attempts to rehabilitate you, deter others from committing similar acts, protection of the community, through the sentence of this court that you be placed on probation for a period of 18 months. Along with the statutory terms of probation are the following special conditions. You must comply with the requirements of drug testing as directed by the field agent. You must not use or possess any controlled substances or drug paraphernalia unless prescribed for you by a licensed physician or be with anyone you know to possess these items. You must complete outpatient or residential substance abuse treatment when referred by the field agent. You must complete a substance abuse assessment when referred by the field agent. You must complete a psychological evaluation when referred by the field agent. You must complete mental health or other recommended treatment following assessment by a qualified community-based service provider. You must waive confidentiality and allow any treatment program that you are required to attend to disclose information to your field agent. You must comply with the Michigan Department of Corrections electronic monitoring program when referred by the field agent. You must not engage in any assaultive, abusive, threatening, or intimidating behavior. You must not have any verbal, written, electronic, or physical contact without permission of the field agent with anyone you know that has a felony record. You must not change your residence unless you first obtain written permission from the field agent. You must not use any object as a weapon. You must contact the supervising field agent no later than the first business day following your placement on probation or release from jail. You must comply with all written and verbal orders made by the field agent. You must allow the field agent into your residence at any time for probation supervision. You must submit to a search of your person or property without the need of a warrant if the field agent has reasonable cause to believe you have items which violate your conditions of probation. You must report any arrest or police contact, loss of employment, or change of residence to the field agent within 24 hours, weekends and holidays accepted. You must notify the field agent of service of any personal protection order upon you within 24 hours of that service, weekends and holidays accepted. You must be in your approved residence between the hours of 10 p.m. and 7 a.m. unless excused by first obtaining written permission from the field agent. You must not have any verbal, written, electronic, or physical contact with Nevaeh Michelle Gates, either directly or through another person. Must not be within 500 feet of her residence, school, or place of employment. You must make genuine efforts to find and maintain legitimate employment of a minimum of 30 hours a week. You must pay a $68 state cost, pay a crime victims assessment of $130. Must pay a supervision fee of $30. If the Department of Corrections decides to put you on electronic monitoring, then it'll be $60 a month, court costs of $500, a fine of $500. How much are you charging for attorney fees?
$590.
And $590 in court appointed attorney fees. Court's gonna order you to do 100 hours of community service. Successfully complete that 100 hours, the court would reduce your fines and costs by $600. Must not possess, purchase, or attempt to purchase anything that contains ephedrine or pseudoephedrine without first obtaining permission from the field agent. You must set up an installment payment agreement with the Clare County Clerk's Office within 30 days of your release from jail. You are entitled to appellate review of your conviction and sentence. If you're unable to hire your own attorney, the court will appoint an attorney for you and furnish the attorney with the necessary records and transcripts to perfect an appeal. The request for the appointment of appellate attorney must be made in writing within 42 days, sent directly to the court. Please sign the notice of appellate rights form when it's presented to you. You will be getting out of jail, Mr. Wiki. Ms. Medley, does he need to phone somebody or just report to the office?
Mr. Wiki, if you are released from jail, then you do need to contact me. Do you still have my phone number?
I believe it's still in my wallet. If not, I can just come right across there and get one.
Okay, that's
Or
fine.
Mr. Wiki, you can call my office and we'll provide that information.
Yes, sir.
Good luck to you, Mr. Wiki.
Yes, sir.
Mr. Ackerman, they have to get him. You're all set, Mr. Wiki. Can we get Mr. Ackerman?
You should be in the queue.
Okay.
Mr. Ackerman and Mr. Monty are just staff. This says Mr. Moore. You want to put anything on the record with those two?
I do not, no.
No. So you can cancel Mr. Ackerman. We're not going to do anything on the record. Anything new happening in those cases that you want to put on the record? All right.
Mr. Monte then?
No, we can go without him too. Believe that takes care of all your cases, Mr. Moore?
A little herky jerky, but yes, Your Honor.
Yeah,
Thank you.
thank you.
For security corrections, we no longer need Ackerman.
For sentencing.
For security corrections, may we have Orion Levante?
Todd, if you could unmute your phone, please. We're getting Ms. Levante.
All right, thank you.
Thank you, sir.
In the case of the People versus Maria Anna Labonte, counsel identified for the record, please.
Sean Brzezowski, on behalf of the people.
Thank you, Your Honor. Todd Diedrich appearing on behalf of Ms. Labonte.
And you are Maria Anna Labonte?
Yes, Mariah.
Mariah? All right. Previously, you appeared in court, pled to the charge of tampering with electronic monitoring device plus habitual criminal fourth. That made that a felony with a maximum penalty of 15 years in prison. Pre-sentence investigation report has been prepared. Sentencing guidelines are 0 to 34 months. Mr. Diedrich, have you had the opportunity to review that pre-sentence investigation report with your client?
I have, Your Honor.
Anything of a factual nature that you wish to add to, explain, or controvert?
No, Your Honor.
Any objection to the scoring of the guidelines?
No, Your Honor.
Ms. Ambrositis, on behalf of the people, anything regarding the pre-sentence investigation report?
Your Honor, we've had the opportunity to review the pre-sentence investigation report. We do find it to be factually accurate. I've also reviewed the prior record variable scoring and the offense variable scoring and find those to be accurate as well.
Ms. Labonte, is there anything you wish to say to the court before the court passes sentence?
No.
Mr. Diedrich, on behalf of your client?
Thank you, Your Honor. Ms. Labonte, I believe has been sitting for quite a while with, prior, she wasn't getting any credit initially for about a month. And then the prosecutor had offered that her credit begin at the time of the plea, which was on June 28th. And I see that the department is stating she's not entitled to credit. I would ask the court to consider the 43 days that she's already served since the date of the plea, which did not include approximately 25 days or so, or 20 days or so prior to that. Would ask the court to consider the 365 days, subtracting the 43 days, I believe is 322 days. The court would consider imposing that, or in some form or fashion where she would get the credit since the date of the plea. And speaking to Ms. Labonte, she does have some plans on moving on with her life. I think she's growing up a little bit, unfortunately, the hard way, but she has also asked for the court's consideration of some possible rehab, excuse me, towards the end of the sentence. So I would ask the court to consider that as well. Thank you.
Ambrositis, on behalf of the people?
Yeah, we ask to follow the recommendations and the plea agreement in this matter.
Court has reviewed through the pre-sentence investigation report, does provide for sentencing guidelines of 0 to 34 months. In order to punish you for what you have done, to attempts to rehabilitate you, deter others from committing similar acts, and for protection of the community, to the sentence of this court, that you be sentenced to 12 months in the county jail. The court will give you credit for 43 days served since it was part of the plea agreement. But normally you're not entitled to any jail time when you're on parole when you get arrested for a new charge. You must pay a $68 state cost, a crime victim's assessment of $130, court costs of $500, a fine of $500. How much are you charging for attorney fees?
$350, Your Honor.
$350 in court-appointed attorney fees. You must set up an installment payment agreement with the Clare County Clerk's Office within 30 days of your release from jail. You are entitled to appellate review of your conviction and sentence. If you're unable to hire your own attorney, the court will appoint an attorney for you and furnish the attorney with the necessary records and transcripts to perfect an appeal. The request for the appointment of appellate attorney must be made in writing within 42 days sent directly to the court. Please sign the notice of appellate's rights form. Bond is canceled. Remanded to the custody of the Sheriff's Department for carrying out the sentence. You're all set, Ms. Labonte.
Thank you.
I believe that's your only case, Mr. Diedrich, today.
Thank you, Your Honor.
Good morning, Ms. Tomzik.
Morning.
Good morning. We are just waiting on your, the arraignment. The next one is for Jenna Gashka.
Yes, Ms. Koshka actually gave me permission to sign her name to a arraignment form. I can get that to the court. Well, I have internet here, I'm sorry. I would say I could get it to the court later today, but I would have to fax it over to the court.
All right, so she's gonna waive arraignment on all three cases?
Your Honor, I'm sorry.
She's going to waive arraignment. You're gonna fax, you're gonna send in a form at some point. Is that correct?
Yes.
All right.
Yes, Your Honor.
Do you want Mr. Heinsohn instead?
Yes, I guess.
I have Mr. Reed.
All right, calling the case of People versus Richard Joseph Reed, is he present in the courtroom? No.
Mr. Reed, can you hear the court? Mr. Reed,
Yes,
can you hear the court?
yes, I can.
Thank you.
Counsel identify the case.
Which represents Karen Dale People?
Thank you, Your Honor. Karen, Secretary, on behalf of Mr. Reed.
And
Yeah,
you're
you're
Richard
excellent on
Joseph
those.
Reed.
Yes, Richard Reed.
All right. This is set as a pretrial. A pretrial summary has been presented to the court. Have you received that, Ms. Tomczyk?
Yes,
Your Honor, I have not, but I am assuming that the prosecutor. I am having difficulty getting into the email with no internet, so I would ask that we set the matter for a status conference in 30 days, Your Honor.
All right. Court will set a status conference for the next motion day, August 23rd at 10 a.m. Pretrial summary has been presented to the court. The court signed that, and hopefully you'll have a copy of it before the next status conference. Anything else? Ms. Thompson?
Oh, yeah.
All right, you're all set, Mr. Reed, for today.
okay, thank you.
Calling the case of the People versus David Ryan Hines. Your parents?
Karen Tomczyk for Mr. Your Honor. I did receive an offer that I have not been able to discuss with Mr. Hines yet. So the court would like a breakout room with him.
All right. Do we have Mr. Knapp here, present? No? Is Mr. Knapp online?
No.
No. All right, court, take a short recess.
All rise. Court's in recess.
So, what's that for the next hearing? After trial, right? So, when you're- So, or not so much.
could go longer.
And then it's a pre-trial, so it's-
That doesn't happen.
So it's I never do that. For the docket.
Yeah, it's not
Like,
for the chair.
this stuff before. And then under the calendar, write the date, and then you have to change the time. Add the judge. Bill. Add. Get here, you accept. Add again. Until you see it shows up there, that's how you know you were.
Mr. Hines, you just have to hit the join button so you can, thank you.
Ray G. Mink, presiding.
You may be seated. We're calling the case of People versus David Ryan Hines. Counsel identify.
Thank you, Aaron Tomchek, on behalf of Mr. Hines.
You are David Ryan Hines.
Yes, Your Honor.
The probation violation case, 9 counts have been filed. How do you wish to proceed today, Ms. Tomchek?
Your Honor, we received an offer from probation in which Mr. Hines would be pleading to count 3, 5, 7, 8, and 9. The remaining counts will be dismissed. Probation would recommend unsuccessful discharge. There is no sentencing.
All right. Mr. Hines, how old are you?
I'm 35 years old, Your Honor.
You raise your right hand to be sworn.
Do you solemnly swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
All right. You're currently on probation for domestic violence, 3rd offense as a felony. It carries a maximum penalty of 5 years in prison. The minimum is discretionary with the court. Count 3 is violation of special condition 4.25. Count 5 is violation of special condition 4.25. Count 7 is violation of special condition 4.25. Count 8 is violation of special condition 9.70. And count 9 is violation of special condition 4.25. Is one of 3 possible pleas you may make to these charges. You may plead guilty if you are guilty, but don't plead guilty unless you are guilty. You may plead not guilty, or you may stand mute, in which event the court will enter a plea of not guilty for you. You understand that one of 3 possible pleas you may do, Mr. Hines?
Yes.
Answering to count 3, violation of special condition 4.25, how do you plead?
Guilty.
Answering to count 5, violation of special condition 4.25, how do you plead?
Guilty.
Answer 7, violation of special condition 4.25, how do you plead?
Guilty.
And answering to count 8, violation of special condition 9.70, how do you plead?
Guilty.
And answering to count 9, violation of special condition 4.25, how do you plead?
Guilty.
You understand that if your pleas are accepted, you will not have a hearing of any kind and therefore give up the following rights. The right to have a contested revocation hearing, the right to be represented by an attorney, the right to a court-appointed attorney if you're unable to afford one. You are represented by Ms. Tomchek in this matter. That the maximum possible sentence could be 5 years in prison. The minimum is discretionary with the court. That you give up the right to appear at a hearing, present evidence, cross-examine witnesses. You give up the right to have the prosecution or probation office establish a violation by a preponderance of the evidence. You give up the right to remain silent and not have that silence used against you during the hearing, and you give up the right to testify at the hearing if you wish to do so and have your testimony considered in the same manner as any other person's testimony. Do you understand these rights?
Yes, Your Honor.
You understand by pleading guilty, you give up each and every one of those rights?
Yes.
Has anyone promised you anything beyond what was stated in the plea agreement to induce you to plead guilty?
No.
Has anybody threatened you or your family in order to induce you to plead guilty?
No,
Has anybody promised you that if you pled guilty, this court would be lenient upon you in any way?
no,
Is it your own personal choice to plead guilty?
yes,
And are you doing so freely and voluntarily?
freely.
And voluntarily?
No, I'm doing it on my own, freely. Nobody's,
Well, that's it. Nobody's forcing you to do this, is that correct?
that's correct, yes, it's my decision.
In light of everything that the court has told you, do you still wish to plead guilty?
Yes, Your Honor, yes,
And part of your probation was to report any arrest or police contact, loss of employment, or change of residence to the field agent within 24 hours, weekends and holidays accepted, is that correct?
yes,
And you were released from jail on or about June 7th, and you failed to contact your agent as required, is that correct?
yes,
And you failed to report that police contact from June to the agent, is that correct?
yes,
And also, you were arrested on or about June 28th, and you failed to contact your agent regarding that, is that correct?
yes, Your Honor,
And you were supposed to set up an installment payment agreement as part of this probation to pay on your fines and costs, is that correct?
yes,
And you failed to set up a payment plan as of June 29th of 2021, is that correct?
yes,
And you were released from the Grand Traverse jail back on June 29th of 2021, and you failed to contact within 24 hours the probation department, is that correct?
yes,
Court finds a factual basis for the plea. Do you agree, Ms. Tomczyk, that there's a factual basis for the plea?
Yes, Your Honor.
Does the court comply with the court rules?
It has, Your Honor.
Court has not agreed upon the possible plea or the possible sentence with either prosecutor, defendant, or anyone acting in the interest of either. Court is convinced the plea is understandably, voluntarily, and knowingly made. Plea is accepted and ordered entered upon the records of this court. We'll set sentencing for August 23rd at 10 a.m. Defendant is referred to the Department of Corrections for the preparation of an updated case report. Bond canceled. Case is adjourned to the date time set for sentencing.
Your Honor, and I'm assuming that's because the court wants an updated case report. Mr. Hines would waive that, right?
I would like to have an updated case report.
Okay, thank you, Your Honor.
All right. You're all set, Mr. Hines.
so what do I do, just wait in jail for court?
Yep. If we can get one updated earlier and we can make arrangements for earlier sentencing, we'll try to do that, okay?
All right, thank you.
All right. Following the case of the People versus Bryant, Allen, Knapp.
Good morning, Your Honor. Mark Webb on behalf of the people.
Morning, Your Honor. Karen Tomczyk on behalf of Mr. Knapp.
Mr. Knapp is not present in the courtroom. He's not present on Zoom. It's set for sentencing. He has failed to appear for the pre-sentence investigation report. Court's going to cancel and forfeit his bond, issue a bench warrant for his arrest. Bond in the amount of $100,000 cash.
Did you say, I'm sorry, Your Honor, you said 100,000?
100,000 cash.
Am I excused?
Yes, you're done, Mr. Hines.
Thank you.
Following the cases, the People versus Angelica Lee Pitt.
Morning, Your Honor. Mark Webb on behalf of the people.
Morning, Your Honor. Karen Tomczyk on behalf of Ms. Pitt.
Your Honor, Austin R. Rowe appearing in case number 216690 FH for Ms. Pitt.
All right. And you are Angelica Lee Pitt?
Yes.
All right. We have 3 cases set for pretrial. Have you received pretrial summaries on behalf of those cases, Ms. Tomchak?
I have not, Your Honor. Again, I'm assuming they were mailed to me, and that I cannot get to my email at this point, Your Honor, based on the lack of internet here in Gladys County. However, I was planning on conducting a trial and having this matter set for a status conference, I'm gonna say in 60 days.
Court's received 2 pretrial summaries for 2 of the cases. And the court's gonna sign those, and whenever the court receives the 3rd one, the court will sign that one also.
Your Honor, which file didn't have one?
Looks like 6688. That was gonna be dismissed with the others too, so I guess it doesn't really need one, but. And status conference will be set 60 days out in these 3 cases. With the trial, final pretrial and trial date being set after that.
Your Honor, we did email the pretrial summary on that one.
Probably floating around somewhere.
I can print it off to the,
That'll work. Going towards case 20-6476-FH. Previously, Ms. Pitt appeared in court. Pled to the charge of controlled substance, possession of methamphetamine, a felony. It carries a maximum penalty of 10 years in prison. The minimum is discretionary with the court. Pre-sentence investigation report has been prepared. Sentencing guidelines have been determined to be 0 to 11 months. Mr. Rowe, have you had an opportunity to review that pre-sentence investigation report with your client?
I have, Your Honor.
Anything of a factual nature that you wish to add to explain or controvert in that report?
Your Honor, just to add some facts, I think that Ms. Pitt told me that she has been going to NA during this time of this case being litigated. She would like to go to rehab. She's been considering that, waiting to see whether she goes to jail. And
you want that added to the report, or is that just for sentencing purposes?
well, Your Honor, I guess you just add to the for sentencing purposes, add to the report, I guess, that NA. She's been attending NA, Your Honor. Pardon me.
All right, we'll have that added to the report that she has been attending NA. Do we have a date when she started?
Ms. Pitt, when did you start attending NA?
A week after I was arrested.
Okay.
I heard a couple other things since last time too.
So would that be last October or so?
Yes.
Okay. So we'll say she's been put in the report, she's been attending NA since October of 2020. Anything else, Mr. Rowe?
No, Your Honor.
Any objection to the scoring of the guidelines?
No objection, Your Honor.
Mr. Webb, as to the pre-sentence investigation report, anything?
I've read the report, there are no additions or corrections to it, and the guidelines are correct as court.
Ms. Pitt, is there anything you wish to say to the court before the court passes?
Since last time we were sentencing, I signed up for 1016, got back in mental health, and I signed up for rehab and on the weekend.
Mr. Rowe, on behalf of your client?
Your Honor, on behalf of my client, I would say that she has been trying to address the issue, underlying issue that brought her into court today, Your Honor. She's asked the court to honor the plea bargain agreement.
Mr. Webb, on behalf of the people?
Your Honor, I'd ask you to follow the plea agreement and the recommendations of the probation department.
Court has reviewed through the pre-sentence investigation report, does provide the sentencing guidelines of 0 to 11 months. In order to punish you for what you have done, to attempt to rehabilitate you, deter others from committing similar acts, and for the protection of the community, the sentence of this court that you be placed on probation for a period of 3 years. Along with the statutory terms of probation, you have the following special conditions. You must not use or possess alcoholic beverages or other intoxicants or any places that serve alcohol. You must comply with the requirements of alcohol testing as directed by the field agent. You must comply with the requirements of drug testing as directed by the field agent. You must not use or possess any controlled substances or drug paraphernalia unless prescribed for you by a licensed physician or be with anyone you know to possess these items. You must use prescription drugs only as prescribed for you by your licensed physician. You must complete outpatient or residential substance abuse treatment when referred by the field agent. You must complete a substance abuse assessment when referred by the field agent. You must perform 100 hours of community service as directed by the field agent. If you successfully complete it, the court will reduce your fines and costs by $600. You must complete mental health or other recommended treatment following assessment by a qualified community-based service provider. You must waive confidentiality and allow any treatment program that you are required to attend to disclose information to your field agent. You must not engage in any assaultive, abusive, threatening, or intimidating behavior. You must not have a verbal, written, electronic, or physical contact without permission of the field agent with anyone you know to have a felony record. Must not use any object as a weapon. You must contact the supervising field agent no later than the first business day following your release from jail. You must comply with all written and verbal orders made by the field agent. You must allow the field agent into your residence at any time for probation supervision. You must submit to a search of your person or property without the need of a warrant if the field agent has reasonable cause to believe you have items which violate your conditions of probation. You must report any arrest or police contact, loss of employment, or change of residence to the field agent within 24 hours, weekends and holidays accepted. You must make genuine efforts to find and maintain legitimate employment of a minimum of 30 hours a week. You will serve 6 months in the county jail with credit for 2 days served. You must pay $68 state costs, crime victims assessment of $130, supervision fee of $30 a month. That can go up to $60 a month if one corrections decides to put you on electronic monitoring. Court costs of $500, a fine of $500. How much are you charging for attorney fees?
Estimate of $500, Your Honor.
$500 for attorney fees. Probation officer of this court or any other supervising agent may, pursuant to MCL 771.4, apprehend, detain, confine a probationer who is in violation of probation condition or who is conducting herself inconsistent with the public good. You're not allowed to use or otherwise possess recreational marijuana or be in the home of anyone who uses recreational marijuana. You must not possess, purchase, or attempt to purchase anything that contains ephedrine or pseudoephedrine without first obtaining permission from the field agent. Your driver's license is going to be suspended for 1 year. Restricted will be allowed after 60 days. You must set up an installment payment agreement with the Clare County Clerk's Office within 30 days of your release from jail. The court has no objection to you going into an inpatient program before the end of your sentence. If you successfully complete it, the court will suspend the jail time. You are entitled to appellate review of your conviction and sentence. If you're unable to hire your own attorney, the court will appoint an attorney for you and furnish the attorney with the necessary records and transcripts to perfect an appeal. The request for the appointment of appellate attorney must be made in writing within 42 days sent directly to the court. Please sign the notice of appellate rights form. Bond is canceled, remanded to the custody of the sheriff's department for carrying out the sentence.
Can I have a couple hours to get everything in order? I really didn't think I was gonna get jail time. I thought it was gonna be suspended. Then have a
Any
couple hours.
objection, Mr. Webb, to her reporting today by 5 o'clock to the jail?
I'm sorry.
All right, court will allow you to report to the jail by 5 PM today.
Thank you. I'm sorry. I have a doctor's appointment. Why is there any way?
Court will allow day parole for medical purposes.
So can I have?
So bring proof to the jail, bring proof to the jail that you have an appointment.
Okay.
And they will let you out for the appointment, but then you have to return.
Okay.
Karen, I think you're all set.
Thank you. I was just making sure I knew what happened in the case.
In the case of People versus Sarah Arlena Sweet.
Desiree.
Desiree. So it's a status conference. Is a new pretrial summary being issued for this case?
Just received the second one, Your Honor. It looked significantly different from the first one, but I guess.
Wondering if it's still trying to find the old one.
It appears that there's one for today. That is guilty or no contest. Count 1 is count 2, dismiss count 3. And the habitual notification, BK day-for-day credit for successful substance abuse treatment. Restitution be determined to the victims.
Do you believe that the same as what was offered earlier?
Yes, it is, Your Honor.
Court will sign it and put it in, place it in the file. The client does not plan on taking advantage of that offer, is that correct?
As of today, no, Your Honor, we're still in discovery mode. I had some discovery coming from the RISE program, which was used to be the women's shelter that does interviews of sexual assault victims and such. And they haven't gotten their stuff. We're sending them over a second. I talked to the director last weekend. She was surprised that they had returned our request.
All right. This will go on the trial docket with the final pretrial and trial being set. Doesn't appear that there's been one set yet. But I can see. You want to have a status conference set before those, or?
Yes, please, Your Honor.
All right. So status conference next. Final pretrial and trial date.
If I may inquire, since we're going down the CSD rabbit trail, apparently is the defendant going to follow through with a formal report on that with the sheriff's department? They've attempted to contact her to start the investigation and have not received any assistance on our behalf.
My client tells me that she has attempted to call them and talk to them. She's actually spoken to someone who's not followed through with the meeting that was planned. So we will go over right now when they get here today.
Anything further for today?
Just like we do a little paperwork here for the secretary.
Sure.
Ms. Hammerstein, I found this in talking to Desiree's file, but I don't recognize it. Does that come from your office? From the waste office?
No, she isn't.
Yep.
I'm not sure either, so. Yeah. I should have the rest of our investigation back, by the end of this week or early next week, and then I'll be in touch with precise.
So you want a status conference set for end of September? Sure. Okay, and then the final pre-trial will be set after that and trial date. Okay,
Thank you very much.
all right, you're all set. Thank you.
Ms. Montoya, can you unmute your phone, please?
Yes.
Thank you.
Well, in this case, People versus Haley Christine Montoya. Counsel identify for the record, please.
Morning, Honor, Mark Webb on behalf of the people.
Your Honor, Austin R. Rowe appearing on behalf of Mrs. Montoya.
And you are Haley Christine Montoya?
Yes.
This is set as an arraignment. How do you wish to proceed today, Mr. Rowe?
Your Honor, Ms. Montoya waives the reading. She furthermore pleads not guilty.
All right, not guilty plea will be entered on behalf of Ms. Montoya. This will be set on a trial docket with the pretrial being set next. You're all set, Ms. Montoya.
Okay, thank you.
And we have Mr. Dietrich in. Calling the cases, the People versus Christopher Carl Dietrich. Counsel identify for the record, please.
Your Honor, Austin R. Rowe appearing for Mr. Dietrich and me. Mr. Dietrich and I talked with each other in the breakout room.
You may. Court is in recess.
All rise.
Mr. Dietrich, if you just hit the join button.
All rise. Court's back in session. Honorable Roy G. Mink.
You may be seated. On the cases, the People versus Christopher Carl Dietrich. Counsel identify for the record.
People.
Your Honor, Austin R. Rowe appearing on behalf of Mr. Dietrich.
You are Christopher Carl Dietrich.
Yes, sir.
Previously, you appeared in court and pled to the charge of operating while intoxicated or impaired or under controlled substance, third offense, plus habitual criminal offender third. That makes that a felony with a maximum penalty of 10 years in prison. You also pled to the charge of operating while license suspended or allowing somebody to operate with a suspended license, second offense. That's a misdemeanor, carries a maximum penalty of 1 year in the county jail. Pre-sentence investigation report has been prepared. Sentencing guidelines have been determined to be 19 to 57 months. You also pled to probation violations and file 19-6190-FH, in which you are on probation for tampering with electronic monitoring device, plus a habitual third that made that a felony with a maximum penalty of 4 years in prison. You also pled to probation violations in files number 18-6015-FH, in which you are on probation for 2 counts of resisting and obstructing an officer, felonies that carry a maximum penalty of 2 years in prison. And for weapons, firearms, reckless use, which was a misdemeanor. You shouldn't be on probation for that one. An updated case report has been prepared in that case. Sentencing guidelines were 2 to 17 in the one file and 0 to 25 in the other file. Mr. Rowe, have you had an opportunity to review those reports with your client?
I have, Your Honor.
Anything of a factual nature you wish to ask, to explain, or controvert?
No, Your Honor. We had discussed the credit for jail credit, but in my chance since talking to Mr. Dietrich, I've recalculated. It looks like it's accurate at 260 days for Mr. Dietrich.
Okay. All right. Any objection to the scoring of the guidelines?
No, Your Honor.
Ms. Ambrositis, on behalf of the people?
We've had an opportunity to review the pre-sentence investigation reports in not only the new case, but probation violation sentencing, and the opportunity to review the prior record variable scoring and the offense variable scoring and find this to be accurate.
Mr. Dietrich, is there anything you wish to say to the court before the court passes sentence?
Yes, sir. Sir, I'd just like to address the courts and take full accountability for my actions. I've since 2018, in the beginning of this case, I've had a repeated in and out of trouble situation, and it's been due to an addiction and alcoholism and things like that. I've as I said in my PSI, I said that when I was released last from the RAP program, I did extremely well. I moved to Ionia and things, I didn't, they said that I lost my job there. I didn't lose my job. I was exposed to COVID and I couldn't live with my mom. So I had to have somewhere to stay. So I had to come back to Clare County where I knew. During the stressful time, I slipped my sobriety and I learned something from it. And there's a few things in this case that I'm grateful for. You know, I'm grateful for that I hurt no one, that nobody was physically hurt. And that's extremely the most thing that I'm grateful for. I'm also grateful that I learned a lesson through this, that even though I was headstrong and I was determined to stay sober and stay off from use of any substances from the things that I learned in the program, the very first time that I come across a stressful situation, I without thinking, without anything, I completely fell back and I bought a bottle of alcohol. This event here with this drunk driving, this was one use of alcohol. And I knew from buying the bottle in the first place that I was screwed, and that I'm grateful to know that it's something that I have to actually look into. I can't just be headstrong and think I have it on my own. I have to use my support team, and I should have asked for help. And this is something that I've learned from this, and I hope to carry on forward through this and be able to use this knowledge in the future to be able to maintain and retain my life. That's all I'd have to say. Thank you.
Mr. Rowe, on behalf of your client?
Your Honor, my client is quite eloquent in his discussion of his substance abuse, Your Honor, and what he's learned. Your Honor, I asked the court to take into consideration that the stresses that he was under at the time, that he has now had time to think about it, that he's thought out how to keep it from happening in the future. Your Honor, I think this is probably substance abuse, including alcoholism, is probably what's been driving his criminal history in the last few years. For those reasons, ask the court to follow the plea bargain agreements in both the felony file 6015FH and the files on which he's on probation, except the recommendations of the and adopt the recommendations of the probation officers in all three cases, Your Honor.
All right. Ms. Ambrositis, on behalf of the people?
We ask to follow the recommendations on the agreement in this matter.
Court has reviewed through the pre-sentence investigation report, does provide for sentencing guidelines of 19 to 57 months. This is an agreement for a cap at 14 months on the low end. Court has also reviewed through the updated case report. And the guidelines in that are 2 to 17 months in the one case and 0 to 25 in the second case. In order to punish you for what you have done, or attempts to rehabilitate you, deter others from committing similar acts in protection of the community, be the sentence of this court. File number 20-6519-FH, that you be sentenced to the Michigan Department of Corrections for a period of 14 months to 10 years with credit for 260 days served. You must pay $150 reimbursement, restitution. You must pay a $60 DNA fee if it hasn't been paid yet, $118 in state costs, crime victims assessment of $130, court costs of $500, a fine of $500, and attorney fees. How much are you charging?
I estimate $500, Your Honor.
$500 in attorney fees. You must set up an installment payment agreement once you're released from prison on those, for those fines and costs. As to file number 19-6190-FH, the sentence of this court that your probation be revoked as unsuccessful, that you be sentenced to time served. No, are you charging additional fees for the other cases, Mr. Rowe?
Your Honor, I think in this case I will.
Because if you were, I was just going to add them to the new felony file instead of these old files, but. All right. As to file number 18-6015-FH, the sentence of the court that your probation be revoked as unsuccessful discharge, and that you be sentenced to time served in that case also, no additional costs. You are entitled to appellate review of your conviction and sentences. If you're unable to hire your own attorney, the court will appoint an attorney for you and furnish the attorney with the necessary records and transcripts to perfect an appeal. The request for the appointment of appellate attorney must be made in writing within 42 days, sent directly to the court. Please sign the notice of appellate's rights form. Bond is canceled. You're remanded to the custody of the Michigan Department of Corrections for carrying out the sentence. I hope this is a good learning experience for you, Mr. Dietrich. And I realize you now realize that you have a problem and you need help. And when you get those stressors, you have to rely on a support group.
Absolutely.
Good luck to you.
Thank you, sir.
Judge, did you revoke probation in both of your files?
Yes.
Okay.
Ms. Wilkie needs to continue.
Yes.
Okay, and she is coming this way.
All right. You're Mr. Chaston?
Yes.
Let's call the case of the people versus Stephen Allen Chaston. You're a pro per case, or you're represented by Mr. Rowe on one case?
Yeah.
And the other is a probation case?
Yes.
All right. Councils, identify for the record, please.
Your Honor, Austin R. Rowe, appearing on behalf of Mr. Chaston.
Joe resides appearing on behalf of people.
All right. This was just set as a status conference, and both files, one the PV file. Mr. Chaston, you are not requesting an attorney for the probation violation file?
I thought Austin was doing that.
Okay. Well,
Your Honor, I believe I am as the attorney on that file.
all right. Well, if you're not, the court will appoint you for it. Doesn't appear that we have you listed in our court file as representing him, but you will from the future. All right. Anything happening in these files? Anything we need to discuss?
Your Honor, for various and sundry reasons, I hate to do this, but I'd request another status conference in these two files. And before Mr. Chaston goes, I'd like to ask him his current address and phone number.
205 East 4th Street, Apartment A, Claire.
Received mail there?
Yeah, yes.
You have a phone number also?
989-472-6228.
Okay, I'm catching just part of this. 472, what is it?
6218.
6218, and what's the street again, please, sir?
4th Street.
4th Street?
4th.
East 4th Street.
That's Claire?
Yes.
Okay. Thank you.
All right. The only time I think I can schedule a status conference would be in 2 weeks on this case. We're already set for a final pretrial on the 28th of September. Would you like a status conference in 2 weeks, or just wait until the final pretrial?
In 2 weeks, Your Honor.
All right. We'll put this on the docket for August 23rd at 10:20 a.m. Sorry it took so long, Mr. Chaston, for you to wait for this.
It's fine.
All right. You're all set for today. One in the case versus Samantha Ann Cardos.
Your Honor, Austin R. Rowe, appearing on behalf of Ms. Cardos.
You are Samantha Ann Cardos?
Yes.
Oh, okay.
All right. And this was set as an arraignment. How do you wish to proceed?
Your Honor, Ms. Cardos waives the reading and pleads not guilty.
All right. Not guilty pleas will be entered on behalf of the defendant. This will be set on the trial docket with the pretrial being scheduled next. You're all set, Ms. Cardos.
All right, thank you.
In the case of the People versus Erica Sue Jensen.
Yes, sir.
Your Honor, Austin R. Rowe, appearing on behalf of Ms. Jensen.
Do we have Erica Sue Jensen?
Yes, sir.
All right. So schedule is a pretrial. A pretrial summary has been given to the court. Have you received a copy of that, Mr. Rowe?
I believe I did, Your Honor. Yes, I did.
All right.
And may I speak with Ms. Jensen for a moment in the breakout room?
You may.
Thank you.
Go off the record.
Leslie notice is, Leslie only wants just a little bit of a bond reduction. He's in 5,000, 10%. He says the bond this, but, you know, the victim's my friend for 20 years. And, you know, I don't think that this is morally right, and they went there with the intention to do that, so. I don't know. You know, bring it up to Austin, maybe Wesley wants to chat with them to maybe get a little bit of a reduction, so we can try and get up for a spot. That's what I told Wesley that I released. That's it. I just didn't know if you want me to re-interview him or not, so. Okay.
Mr. Heron. Didn't take long, did it?
It did that. Just, don't put him on the record. Okay. Raise my right hand.
This is Jensen, right?
Right.
All rise, court's back in session. Honorable Roy G. Mink presiding.
You may be seated. Calling the case, the people versus Erica Sue Jensen, counsel identified for the record.
Show resides appearing on people.
Your Honor, Austin R. Rowe appearing on behalf of Ms. Jensen.
And you are Erica Sue Jensen?
Yes, sir.
This is set for a pretrial. The pretrial summary has been forwarded to the court. Have you received that, Mr. Rowe?
Yes, I have, Your Honor.
And you've discussed it with your client?
Yes, I have, Your Honor.
Anything else you wish to do today?
Your Honor, we'd ask if we could have a status conference in about maybe the next motion day or so that the court has. Next 2 to 4 weeks.
All right. Court will set the status conference for August 23rd at 10:20 a.m. We're in recess.
All rise.
All right, have a good day.
All right, 55th Circuit Court is now in session. The Honorable Roy G. Mink presiding.
You may be seated. In the case of Jack Herman versus Terry Stevenson.
Your Honor, Isaac Post for Mr. Herman.
Stevenson and Carol Stevenson. Neither one's appeared. Are they both deceased?
Terry Stevenson is deceased. Carol Stevenson signed a consent to this order at the beginning of the case, so she might appear, but there's no reason for her to. She's in agreement with what we're doing.
Your motion, go ahead.
Thank you, Your Honor. We filed a complaint to quiet title on this matter. This was a property that Mr. Herman purchased on land contract. He has since paid that land contract in full. The parties to the land contract were Jack Herman as the purchaser and Terry and Carol Stevenson as the sellers. However, Terry Stevenson was the only person that had legal title to the property. That's why we sued both parties. Carol's not technically on the chain of title, but she was on the land contract. That property has since been paid in full. Ms. Carol Stevenson has agreed to that and has signed a order to that effect. Terry is deceased. No title can be conveyed without an estate. There's no estate that's planning to be opened, so we filed this quiet title. proper service was, has occurred on both defendants, Terry and Carol Stevenson. Carol signed a consent and Terry was served via publication. So we're asking that you sign, I believe I have a proposed order to quiet title in front of you, and we ask that you sign that.
All right. Court will grant that motion. Court is signing the order to quiet title. We're also here on Cedar Shores Campground Condominium Association versus Kevin Pancoast and Joetta Pancoast.
Yes. Isaac Post for the Cedar Shores Campground Condominium Association.
This is a motion to confirm the sheriff's sale from the foreclosure.
Yes, we did a foreclosure for fees owed to Cedar Shores. That sheriff's sale was conducted on July 14th, 2021. The amount purchased, I believe, was $25,000. That money is being held by the county treasurer. We ask that you execute an order confirming that the sheriff's sale, and then also confirming that the treasurer will hold the funds, that the funds of $8,955.68 can be immediately released to Cedar Shores Campground. The remaining funds shall be held by the county treasurer, and once the redemption period has expired, those funds should be released to Kevin and Joetta Pancoast.
The sale was July 14th, and there's a 6-month redemption period.
That's correct.
Can the court wait for 6 months before it signs an order confirming the sale?
I don't believe that process is necessary. The redemption period is featured in this order. This also would be featured in the sheriff's deed, I believe. I think what this does is it confirms that the sheriff's sale took place, and then it allows for the redemption period to expire. And I don't think any further action from the court would be necessary. And so now I'll be, forthright with the court that I have not personally done a lot of foreclosures, especially ones that bid above the amount that's owed. However, looking at our previous files, motions to confirm sheriff's sale on similar cases were filed immediately, not at the end of the 6-month redemption period.
Court has reviewed the proposed order. Court will grant that motion. We're in recess.
Okay, thank you very much.
All right.